Public support for the death penalty has changed throughout time based on the interpretation of a constitutional rights. Some people view it entirely as a cruel and unusual punishment, while others think it should only be used for certain crimes. Due to those constantly conflicting opinions, states have been changing their laws constantly to reflect the current public view.
To other countries, it seems that the United States falls in the middle ground when it comes to the death penalty.
A lot less strict than other countries, like Middle Eastern countries, or even in the Philippines, but that doesn't mean that that it's okay.
The broad outlines of the criminal justice system are initially defined by the legislature, state and the federal, and the statutes they enact to construct the criminal and penal code. But these statutory provisions are subject to review, revision, and repeal by the litigation on the grounds that the statutes violate some constitutional provision protecting the rights of the accused, the convicted, or the punished. Paramount among these rights are those specified in the Bill of Rights. Three of these constitutional rights in particular bear on the death penalty: the requirement of due process of law, the requirement of equal protection of the laws, and, above all, the prohibition of cruel and unusual punishment.
Between the time this constitutional protection were adopted and the middle of the century, some 160 years, no serious effort was made to challenge the constitutionality of capital punishments as such. As of 1965, no constitutional challenge had been mounted directly against the death penalty itself. The first hint that the Supreme Court might consider the significant question of the constitutionality of the death penalty came in 1963, in a dissent to a denier or certiorari in the case of Randolph versus Alabama. Justice questioned whether capital punishment was constitutionally permissible for the crime of rape, a possible question to raise during the height of the civil rights movement, given that most of the sentenced to death for rape were black men whose victims were white women. Later in 1965, the legal defense found open its attack on the constitutionality of the death penalty in the Arkansas rape case of Maxwell versus Bishop. Maxwell's LDF attorneys argued that although the Arkansas capital statute as sanctioned may have been colorblind, the law as administered was regularly and intentionally used to discriminate against black defendants and so violate their constitutional rights to due process of law and equal protection of the laws.
The LDF secured a court order to suspend all death penalty activities in 1967 on the grounds that the nation's death penalty system was effectively under fundamental constitutional review by the federal courts. The initial challenges were wholly procedural and were marked by some successes: Witherspoon versus Illinois in 1968 and Ralph versus Ward in 1970, and some defeats: McAlpha versus California and Crampton versus Ohio, both in 1971. Together, these cases set the stage for the momentous argument in 1971 to 1972 over whether the death penalty was in violation of the cruel and unusual punishments prohibition of the Eighth Amendment. The Eighth Amendment states, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. And after interpretation, the U.S. Supreme Court came up with a proportionality requirement. It entails that a penalty must be proportional to the crime, otherwise the punishment violates the Eighth Amendment. To fully analyze the proportion of crime to punishment, the Supreme Court covers three factors: a consideration of the offense's gravity and the stringency of the penalty, a consideration of how the jurisdiction punished its other criminals, and a consideration of how the jurisdiction punished the same crime.
The evolving institutional policies on death penalty gain much attention among public. Supporters and opponents appear with evidences that are solid or not for their opinions. Gallup monitors support for the death penalty in the United States since 1937 by asking, "Are you in favor of death penalty for a person convicted of murder?" The last poll in October 2016 gave 60% in favor and 37% opposed. However, when asked, "Do you believe the death penalty is applied fairly in the United States today?" 50% think so, and 44% say it is applied unfairly. The innocence and racial problem are two biggest concerns in social aspect. In total, 156 prisoners have been either acquitted or received pardons or commutations on the basis of possible innocence between 1973 and 2015. It leads people to think that how many victims are actually killed by wrongful execution. According to a study, 4.1% defendants that are sentenced to death are innocent. This study uses survival analysis to model the rate of erroneous conviction of innocent criminal defendants. However, supporters of death penalty say that there's no proof that any innocent person has actually been executed, since increased safeguards and appeals were added to our death penalty system in the 1970s. Besides, many of the claims of innocence by those who have been released from the death row are actually based on legal technicalities. Just because someone's conviction is overturned years later and the prosecutor decides not to retry him does not mean he is actually innocent. For racial problem, the data shows a gap between the population of black and white in many aspects. As of October 2002, 12 people have been executed where the defendant was white and the murder victim black, compared with 178 black defendants executed for murders with white victims. According to the census, in 2014, the national death row population is roughly 42% black, while the U.S. population overall is only 14% black. Also, eyewitness identification, which is a leading cause of wrongful convictions, is even less reliable when the witness is identifying someone of a different race. However, there's no direct evidence to prove the relationship between race and execution.
Another factor in the case against the death penalty is the inability to carry it out correctly. The history of botched executions is as horrific as it is extensive. It is estimated that from 1890 to 2010, 3% of executions were botched, with lethal injection causing the most failures. In 1997, Pedro Medina was sentenced to death in Florida by electrocution for murder. During his execution, a crown of foot-high flames shot from Medina's headpiece and filled the execution chamber with smoke. An investigation showed the fire was caused by the improper application of a sponge to Medina's head. In 1999, Alan Lee Davis was sentenced to death in Florida by electrocution for multiple murders. While in the electric chair, enough blood poured from his mouth to form a stain about the size of a dinner plate before eventually being pronounced dead. After pictures from his execution became highly publicized, Florida discontinued its use of the chair, and to this day it has not been used again. In 2014, Clayton D. Lockett was sentenced to death in Oklahoma by lethal injection for rape, kidnapping, and murder. Defense attorneys warned the state multiple times about using experimental drugs, but Oklahoma went ahead with the execution anyway, remaining in a state of secrecy about the execution and the source of the drugs. It took an hour to find a suitable vein in Lockett, and about 10 minutes after administering the first drug, Lockett was pronounced to be unconscious, and therefore eligible to receive the final two drugs that would kill him, which were known to cause excruciating pain if the person was conscious. Lockett was in fact conscious. The IV used had somehow dislodged, and the drug was pumped into Lockett's tissue instead of his vein. Because a sheet had been placed on top of Lockett, the executioners were oblivious to the fact that something was wrong with the IV. Lockett began to violently move and attempted to speak. About an hour after the execution started, he was declared dead of a heart attack, reportedly in severe agony the entire time.
But I've also said that in the application of the death penalty in this country, we have seen significant problems. Racial bias, an uneven application of the death penalty, situations in which there were individuals on death row who later on were discovered to have been innocent because of exculpatory evidence. And all these, I think, do raise significant questions about how the death penalty is being applied.